Hello everyone. Today we are going to discuss about cyber laws in India. This topic is very important as you know that the cyber crimes are going on in this particular era. If there is society, the progress of the society has to be there. But there are loopholes and the problems also. And law is not a sui generis, but it is a problem centric. That means law does not originate automatically, but only through the problems law originates. So here, if we are talking about the cyber world and the cyber crime, cyber laws are very important to regulate the cyber transactions or internet transactions. In this particular lecture, we are going to talk about all the important aspect under the cyber laws and cyber crimes. This particular law is nothing but the Information Technology Act 2000. There are many amendments also under this particular law. There are new law in 2008 and 2019 also. There are many Supreme Court judgment on these cyber laws. If we talk about the basic idea of this cyber law, digital technology and new communication system have made dramatic changes in our lifestyle. Now businessmen and consumers are increasingly using computers to create, transmit and store information in the electronic form instead of traditional paper documents, as it is cheaper, easier and speedier. This particular day-to-day transactions and their regulation will be only possible when there is proper regulation. In 1996, the United Nations Commission on International Trade Law adopted the Model Law on Electronic Commerce. The United States, by its regulation in 1997, recommended that the state shall give favorable consideration to this model law. In discharge of its international responsibility, the Government of India enacted a law in 2000, which is known as Information Technology Act 2000. The Act extends to the whole of India and it applies also to any offence or contravention thereon committed outside India by any person. Now we'll see the objects of this Act. The Information Technology Act 2000 seeks to achieve the following objects. First, to grant legal recognition to electronic records. That means all the transactions which are covering under electronic record, these are recognized under the law. Second is to grant legal recognition to digital signature for authentication of the information or matters requiring authentication under any law of the country. So this particular act also recognizes digital signature for authentication of the information. Third, to permit retention of information, documents and record in electronic form, where any law requires such retention for a specific period. To foster use and acceptance of electronic records and digital signatures in the government offices and its agencies. Fifth one, to prevent the possible misuse arising out of transactions and other dealings concluded over the electronic medium. Sixth is to prevent and arrest offences as well as deter abuse of information technology. Seventh, to deal with civil and criminal liabilities arising out of contravention of the provisions of the law. 8. To provide for necessary changes in the various provisions which deal with offences relating to documents and paper based transactions. 9th, to facilitate electronic fund transfers between the financial institutions and banks. To legal sanctity for books of account maintained in the electronic form by the banks. All these objects are very essential. In fact, these are the needs, these are the work which are mentioned under the Act. All these transactions, all these tasks have to be covered under the particular Act, the Information Technology Act 2000. Now we'll talk about documents or transactions excluded from the scope of Information Technology Act. So all these documents which I am going to talk about are excluded from this particular Act. A negotiable instrument as defined in section 13 of the Negotiable Instrument Act 1881. Then second, a power of attorney as defined in section 1A of the Power of Attorney Act 1882. Third is a trust as defined in section 3 of the Indian Trust Act 1882. Fourth is a will as defined in section 2 subclause H of the Indian Succession Act 1925. Fifth is any contract for the sale of or conveyance of immovable property or any interest in such property. And sixth, any such class of documents or transactions as may be notified by the central government in the official gazette. So all these documents are excluded from the scope of the Information Technology Act. So first is the negotiable instrument, second is the power of attorney, third is a trust document, fourth is a will, and fifth is any contract for the sale or conveyance of immovable property, and finally any other document which are notified by the central government in their gazette, official gazette. Now we'll see the definition, very important definition under the Act. There are many important definitions. As you know that in our syllabus there are points on this particular cyber law. So e-commerce, then digital signature, cyber crimes and offences, penalties for cyber crimes. So all these points are very essential. First we'll see some important definition. So here are affixing digital signature, which are recognized under section 1 clause D. So affixing digital signature with its grammatical variations and cognate expressions means adoption of any methodology or procedure by a person for the purpose of authenticating an electronic record by means of digital signature. Then asymmetric cryptosystem system, what is this? Which is recognized under section 2 clause 1 subclause F. So asymmetric cryptosystem system means a system of a secure key pair consisting of a private key for creating a digital signature and a public key to verify the digital signature. Now if we are talking about the cyber crime, it is all about the transaction which through computers only. So here section 2 clause 1 subclause I, which defines the definition of computer. So it includes computer means by electronic, magnetic, optical or other high speed data processing device or system which performs logical, arithmetic and memory functions by manipulations of electronic, magnetic or optical impulses and includes all inputs, output, processing, storage, computer software, or communication facilities which are connected related to the computer in a computer system or computer network. So here we need to understand that all these processes which are covering under the computer or this software and the hardware. What is this digital signature? So digital signature means authentication of any electronic records by a subscriber by means of an electronic method or procedure in accordance with the provisions of section 3. So digital signature and this electronic records are very, very important. So digital signature is nothing but authentication of any electronic record by particular method, electronic method and the procedure. Electronic record. Electronic record means data, record or data generated, image or sound stored, received or sent in an electronic form or microfilm or computer generated microfiche. So all these are treated as electronic records. Now we'll see digital signature in detail. As per section 2 clause 1 subclause B of the Information Technology Act, a digital signature means an authentication of any electronic record by a subscriber by means of an electronic method or procedure in accordance with the other provisions of the Act. So here we need to understand that if subscribers are there, the computer operator is there who are doing the particular transaction or any important work, in that particular sense a digital signature is nothing but an authentication of any electronic record. Yes, so here electronic method needs to be applied or procedure needs to be applied in accordance with the provisions of the Act. They should be proper procedure should be followed and all the precautions, reasonable care should be taken by the subscribers. So the subscriber can authenticate an electronic record by affixing his digital signature. So here electronic records by affixing his digital signature. This is very important thing. So affixing digital signature is important on the electronic record for the proper authentication of information. Section 5 provides that when any information or other matter needs to be authenticated by the signature of a person, the same can be authenticated by means of the digital signature affixed in a manner prescribed by the central government. So we need to follow all the rules and the regulation prescribed by the government, state government or the central government. So basically central government regulating all these transactions and the procedures and the methods. So here digital signatures are to be authenticated by certifying officers CH appointed under the Act. So this is under the control of certifying authorities. Digital signature is created through distinct steps. How it is created? So we need to understand that if we are talking about the electronic record and if we want to authenticate all this particular information, so this information should be protected by affixing digital signature. So electronic record is converted into a message digest by using a mathematical function known as hash function, which digitally freezes the electronic record, thus ensuring the integrity of the content of the intended communications contained in the electronic record. The identity of the person affixing the digital signature is authenticated through the use of a private key, which attaches itself to the message digest and which can be verified by any person who has the public key corresponding to such a private key. This will enable any person to verify whether the electronic record is retained intact or has been tampered with. Then any subscriber may authenticate an electronic record by affixing his digital signature. The authentication of the electronic record shall be effected by transform the initial electronic record into another electronic record. So all these steps are very, very essential. Now we'll see digital signature certificate. This digital signature certificate is very important. Any person may make an application to the certifying authority for the issue of a digital signature certificate in such form as may be prescribed by the central government. Every such application shall be accompanied by required fee and certification practice statement. On receipt of application, the certifying authority may, after considering certification practice statement and after making necessary inquiries, grant the digital signature certificate. That means the certifying officer should be very particular about regulating all these transactions, checking, controlling, regulating these particular transactions. So they need to check carefully the authentication and the due care should be taken by him. Issuance, suspension and revocation of digital signature certificate. So this is very important. When there is procedure to recognize the digital signature, there is procedure also for the suspension and revocation of digital signature. There are many reasons which we need to understand when the certificate may be rejected. So here section 35. Any interested person shall make an application to the certifying authority for a digital signature certificate. The application shall be accompanied by filling fee not exceeding rupees 25,000 and a certification practice statement. So here all this procedure should be followed. After scrutinizing the application, the certifying authority may either grant the digital signature certificate or reject the application, furnishing reasons in writing for the same. If he feels or she feels that that means certifying officer or certifying authority feels that there are problems and there are reasons to reject the application, then in that case they can reject the application by giving proper reason. The certifying authority also has the power to suspend the digital signature certificate in public interest on the request of the subscriber listed in the digital signature certificate or any person authorized on behalf of the subscriber. However, the subscriber must be given an opportunity to be heard. If the digital signature certificate is to be suspended for a period exceeding 15 days. So here there may be many reasons. Yes. So all this procedure is very important. Digital signature certificate can be revoked in two different cases. First, it may be revoked either on the request or death of the subscriber, or when the subscriber is a firm or a company, on the dissolution of the firm or winding up of the company. So these reasons are very essential. If the subscriber, if he has taken or she has taken this digital signature certificate and due to the death of that particular subscriber, or suppose subscriber is a firm or a company, and if that firm and the company is now wound up or dissolved, so in that case also the digital signature certificate can be revoked or cancelled. Second, according to section 38 clause 2, the certifying authority may suo motu, that means by their own self they may take decisions to revoke this certificate if some material fact in the digital signature certificate is false or has been concealed. Means intentionally the subscriber is trying to conceal or intentionally he is hiding, or falsely he is stating some wrong statements, or with a malified intention, with a bad intention, he has taken that permission or certificate. So in that case, the certifying authority may cancel the certificate, or the requirement for issue of this digital signature certificates are not fulfilled, then also that can be cancelled or revoked, or the subscriber has been declared insolvent or death. So these are the very important thing which we need to understand. In all these cases, certifying authority may revoke digital signature certificate. Regulation of certifying authorities. What is this? If we are talking about a certifying authority, is a person who has been granted a license to issue digital signature certificate. So under the act only, this authority is empowered, means given power to make a check and balance, to control the transactions, and this permitting a certificate or giving a certificate or cancelling a certificate. So if there are proper reason to cancel, then they can have that kind of power. They can cancel the certificate also. So this power is granted through the act only. So these certifying authorities are to be supervised by the controller of certifying authorities as appointed by the central government. The controller will normally regulate and monitor the activities of the certifying authorities and lay down the procedure of their conduct. The certifying authorities has to follow certain prescribed rules and procedures and must comply with the provisions of the act. That means, although the authority or the persons are appointed under the act, they need to follow all the rules and the regulation which are prescribed under the Information Technology Act 2000. And so here the proper transactions will be there, and there will be proper authentication. So thank you, students. In the next lecture we will continue. Thank you one and all.